There we go. Mr. Perry, is this the lease that you signed with defendant? Mr.
I'm
Perry,
sorry. Yes, that's the lease.
so this is the lease with regards to property that you never occupied, correct?
Yes.
Did all the amenities ever promised to you, were there, when once you did your inspection, were they actually included in the premises?
No.
Tell the judge more about it.
Some amenities that weren't included was the dishwasher, which isn't to me a big deal. It's not required, but it was mentioned at least inside the kitchen was that was occurred instead.
And then I'm about to
Uh,
show you some of your hotel receipts, Mr. Perry. Would you confirm with the court that these are the money you had to pay for alternative housing?
yes.
And is this one as well? Actually, you know what? I need to switch it. Apologize, Your Honor. Is this also for the hotel receipt?
Yes.
And I'm about to show you another receipt, Mr. Perry.
So, before you go on,
Yes, sir.
was there anything that was not present in the apartment that was specifically specified in the lease that would be there? I'm trying to figure out how they breached the lease, how the landlord breached the lease.
Yes, Your Honor.
Clean-
With regards to the dishwasher, it is something that I will share the screen again with the lease. It was a feature of the lease itself. I believe the stove, and Mr. Perry can talk more about that. The stove wasn't functional, and no clean out from the previous tenant. So when Mr. Perry entered the premises, it was as if someone else was still living there. So it wasn't a condition that he could actually stay there for that night.
Are there any photographs of the condition?
Mr. Perry, I've asked that question from my client before, Your Honor. Unfortunately, this actually happened in 2017. Filing was subsequent to that, so he does not have any photographs at this point in time. Is that correct, Mr. Perry?
Yes.
Did you see any pictures of the premises before you moved in, or before you came to take the keys?
Yes. So she actually sent me a couple pictures of some pictures were very old before I think she first even bought the house because the land was laid a little different. But after that, she also sent me um, some videos, but they didn't really justify how the place looked. They looked okay in video. I want when you actually step in and you actually see the details, nothing was clean, finalized tenant. It seemed like he left in a rush, and I came in just after.
And so before you walked out, did you ask the landlord? Did you give notice to the landlord and ask the landlord to clean it up, put it in better condition?
Yeah, exactly. So I sent her a text, and just it was too much for me to kind of text. So we talked the next morning. We spoke about it. She asked me, what's problem? We were kind of negotiating, like, hey, I can clean it up. I'm like, that's cool, that's nice. I was agreeing with her. And I was accepting of it, but it was some other things as well that the apartment that you really can't notice through video, like the walls were like extremely thin. It was extremely cold because it was on top of a garage. So it was extremely cold. But at the same time, we spoke, we tried to negotiate. It didn't work out. So she wanted me to pay $700 more to terminate the lease.
Mr. Perry, is this with regards to a text message that you exchanged with landlord?
Yes.
Your Honor, if I may, I will put another photo that shows my client returned the keys right there and then. And because tenant returned the keys right there and then, landlord was under the duty pretty much proceed with finding another tenant, and the rent meter stopped at that point in time. Because landlord also didn't go through the procedural process for accounting of security deposit, they also waived the right to retain the security deposit. So $700 was for that security deposit, $700 was for the first month rent. My client incurred a lot of damages, had to put all his belongings in the car for a little while, just because of the situation on hand. So it was a unpleasant situation for Mr. Perry, and it wasn't something that he wished for. Unfortunately, it was just a situation that had happened.
All right, any other evidence you have for us?
No further evidence, Your Honor.
I don't believe that you've proven a breach of the lease and an entitlement to your rent plus a security deposit. You know, landlord has a duty to have it in livable condition. I'm not hearing that it wasn't in livable condition. I'm just hearing that Mr. Perry was just dissatisfied with the condition, or offset the rent to repair or put it back. It certainly, I don't believe, constitutes a breach of the lease that would entitle you to a full return of and security. So I'm going to affirm the magistrate court judgment. That is my. I'll enter a formal order on that shortly. But the parties are excused.
Yes, sir. Thank you.
Judge Richardson, may I make some quick announcements on positions 5 and 6?
All right, Mr. Green, of course you may.
On 5, Your Honor, we've already submitted a motion to strike because the company never filed an answer pro se. That was denied. I believe you gave them until today to get an attorney. So if the court would accept, just I can send a proposed order on that to Mr. Townsend.
Who do we have here for Atlantic Construction? I thought somebody answered for Atlantic Construction.
Sergio Vasquez? Yeah, I'm here.
Oh, I didn't. I'm sorry, Judge. I didn't hear that somebody had answered. I thought both of mine were defaults.
All right, we'll come back to you. We'll come back to you both.
That's fine. Sorry about that.
All right, number 6, you said?
Yes, Judge, on 6, if we would just ask to submit a motion for default. This is, there has been no answer filed on this one.
All right, well, we'll let you get the motion in within the next 30 days.
Thank you.
Let me give one last call to folks who I didn't hear from first time around. Matrix Residential, Avery Northwinds versus Letitia Scott. Response. You was denied. UPAth Investments versus Christopher White.
Here, I'm sorry. Hi. I'm the plaintiff. Well, yeah, I'm New Path Investments, I'm sorry.
Are you an attorney?
No,
New Path Investments is an LLC, is that right?
yes, sir.
All right, an LLC has to be represented by an attorney.
I did not know that. Okay,
So we're going to, 30 days, we're going to reset it.
okay,
And to get an attorney and appearance in the case.
okay.
So you are free to go today. You'll get notice.
Thank you.
This is applied for Atlantic Construction too, because we don't have an attorney.
We'll come back to you, sir. All right, let's go to position 10, Lionheart Transportation versus MKS Express.
James Carroll still here for Lionheart. Seeing any appearance by MKS.
Anyone here for MKS? All right. So, counsel for Lionheart, I think this was a motion for default.
Yes, Your Honor. My client is a transportation company, and it engaged MKS Express and Mr. Lemons to provide various transportation services. And Mr. Lemons also, and MKS also signed a promissory note to my client for $19,730.75. And pursuant to the agency agreement for those services, that defendants also ran up charges in the amount of $8,289.48. And we've submitted a verified complaint with liquidated damages, and that Mr. Lemons hasn't responded. We did get service on MKS as well, but we haven't filed the default motion for them as yet. So this today is only as to Mr. Lemons.
All right, so I think you're entitled to default judgment as to Lemons, and you're entitled to the compensatory damages that you've requested. I think there was also a request for attorney's fees. So I need to understand the basis for the request on the attorney's fees.
Yes, Your Honor. So the attorney's fees, the note provides for reasonable attorney's fees. And under 13-111, those are calculated by statute to be 15% for the first 500 and 10% after that. So we would submit that it should just be a statutory calculation for the promissory note, that it would be 15% the first 500, which is $75, and then 10% of the principal and interest after that. I believe that calculation is done in our proposed default judgment.
I have a calculation of $3,400, which doesn't quite add up to me.
That may be for both the. Let me look at the proposed default judgment. Give me a second. Yes, I think that calculation is incorrect. Is it okay if I submit an additional order with the corrected calculations for the court's review?
Yes. Yes, you can send that to Mr. Townsend.
Okay, thank you, Your Honor. I'll do so. May I be excused? This is my only case.
Yes, you may be excused.
Thank you, Your Honor.
All right, position 11, Gerard Lattimore versus Stephen Lackey.
Good morning, Your Honor. David Chang here for Mr. Lattimore, the plaintiff.
All right, Mr. Lackey here. All right, Mr. Chang, got your motion for default judgment. I think everything's in order. I am prepared to sign it. You want a separate hearing to prove damages?
It's up to the court, Your Honor. This particular contract is unliquidated damages. We are prepared to testify as to damages today, but if the court wants to hold a separate hearing, we can do that as well.
If you're prepared to testify to damages, go ahead and hear it.
Okay, thank you, Your Honor. Mr. Lattimore, can you unmute your mic, please? Mr. Lattimore, do you swear to tell the whole truth and nothing but the truth, so help you God here today?
Yes, I do.
Mr. Lattimore, I'm just going to breeze through the agreement that you have with Mr. Lackey because the judge had already determined that the motion for default judgment has been substantiated. Let me just ask you this. Have you given money to Mr. Lackey as a result of the contract that you have with him?
Yes, I have.
Okay, all right. And have you downloaded certain bank statements which show these payments that you have given to Mr. Lackey?
Yes, I have.
Okay. Your Honor, at this point in time, I'm going to share my screen in order to allow Mr. Lattimore to lay the foundation to certain exhibits.
Yes, sir. Go ahead.
Mr. Lattimore, can you see my screen currently?
Yes, I can see it.
Okay. Does it say exhibit on there right now on your screen?
Yes, it does.
Okay. All right. And Mr. Lattimore, I'm going to scroll down a little bit. Do you recognize the document that you see before you right now?
Yes, I do.
Okay. Mr. Lattimore, what is this document?
It's a bank statement that we downloaded from the bank showing that we transferred money to Mr. Lackey.
Okay. And which bank is this?
This is Bank of America.
Okay. All right. And is this your personal account?
That is my wife's account,
Okay. And who's your wife?
Ashley Pruitt.
Okay. And that's Ms. Prude right here where I'm scrolling the mouse.
And she's sitting next to me. If she needs to confirm that she's my wife, she's literally right next to me.
Judge, would you want well, actually, Mr. Lattimore, we'll get to that in just a second. We'll get to that in just a second. This particular PDF, did you download this PDF?
Yes, I did.
Okay, and it was downloaded from your wife's Bank of America account?
Correct, yes.
Okay, and you routinely have access to your wife's Bank of America account?
When I need it, I ask because it's hers. I asked, and she grants permission.
Okay, all right. And on this particular bank statement, sir, how much money was transferred from your wife's account over to Mr. Lackey?
2,500, I believe.
Okay, and are you reading this number that I'm scrolling through right here?
Yes.
Okay, all right. I'm gonna scroll down to a separate page. Mr. Lattimore, is this what is this document that I'm showing you right now?
That is the transfer amount we sent to Mr. Lackey originally.
Okay, and how much was sent over to Mr. Lackey?
$10,000.
And I'm bringing your attention to where I'm scrolling right now. Is this where you're currently referring to, the $10,000 transaction?
Yes, it is.
Okay, all right. So in total, how much money did you transfer over to Mr. Lackey as a result of the contract?
$12,500.
Okay, all right. And is that the amount of compensatory damages that you're asking the court to award today against Mr. Lackey?
I think a little bit more because I also want to include attorney fees and additional damages, I guess.
I understand that, Mr. Lattimore, and I will make that argument to the court in just a second. But in terms of dollar for dollar that you had transferred to Mr. Lackey, what is the amount that you're asking for back?
$12,500.
Okay, thank you, Mr. Lattimore. I have no more questions at this time.
Mr. Chang, could you scroll that back up? I think he said 12.5. Thought that looked like that might have been 12-4.
No, Your Honor. So these are the two transactions that I'm currently circling my mouse over. It's two separate transactions of 1,250. So that's 2,500. And then when we look at the other transaction, 10,000, that's 12,500.
All right, I've got it. I was looking at the wrong entry.
No problem, Your Honor. I'm gonna stop sharing my screen here. Okay. And Your Honor, before I go into my argument about additional damages beyond compensatory damages, as we saw, that was Mr. Lattimore's wife's bank statement. Do you need Mr. Lattimore's wife to testify as well to lay the foundation for that bank statement? We can, if necessary.
Yes, please.
Okay, Mr. Lattimore, can you please get Ms. Pruitt on the screen as well?
Yes, I can. One moment.
Hello.
Good morning, Miss. How are you?
Good morning.
Miss, can you please state your name for the court?
Ashley Pruitt Lattimore.
Okay, and Ms. Pruitt, do you swear to tell nothing but the truth today, so help you God?
Yes.
Okay, and Ms. Pruitt, what is your relationship to Mr. Gerard Lattimore?
That's my husband.
Okay, and Ms. Pruitt, I went through this particular procedure before, but just for the purpose of laying the foundation, I'm going to do it again. Judge, I'm going to share the screen one more time. Ms. Pruitt, do you see my screen? It should say Plaintiff Exhibit A currently.
Yes.
Okay, all right. And Ms. Pruitt, do you recognize this particular document that I have in front of the screen right now?
Yes, I do.
Okay, what is this document?
This is a bank statement from July from my Bank of America account.
Okay, and did you download this particular bank statement?
Yes.
Okay, and you sent it over to Mr. Lattimore to send to me as counsel?
Correct.
Okay, and this document that I'm showing you right now, it's just what is this document?
This is also a bank statement, looks like from my May 2018 statement from my Bank of America account.
Okay, do either one of these two bank statements appear altered from its original form when you first downloaded from your Bank of America account?
No, this is how I received it when I downloaded it from Bank of America.
Okay, Judge, I have no more questions for this witness.
All right.
Your Honor, is there any other reservations you have about laying the foundation? If there is, I can address it, but if not, I would like to move on to my argument about damages beyond compensatory damages.
I'm good. You can go ahead.
Yes, Your Honor. So in our motion, we had requested default judgment. In the complaint as well, there's a prayer for punitive damages in this case. In addition to breach of contract, we have also alleged a fraud claim against Mr. Lackey. And as the court had stated, default judgment is established in this particular case. And under Georgia law, the defendant in default admits to the truth of the allegations in the complaint in its entirety. So we have a fraud claim against Mr. Lackey as well, which is a intentional tort, which as a prima facie threshold would entitle the possibility of the granting of punitive damages. In this particular case, there was a contract between Mr. Lackey and Mr. Lattimore for a development of a land trust to certain neighborhoods in the Atlanta area. And the nature of these land trusts is to take buildings which have been worn down over time and to redevelop it for the benefit of these neighborhoods. That was the purpose of that particular land trust. We do ask the court to take judicial notice of the fact that blighted housing is a big problem in the Fulton County, Atlanta metro area. And this particular case, Mr. Lattimore was trying to do two things. He was trying to earn a small profit from this contract with Mr. Lackey, but he was also trying to better his community by investing in underdeveloped land in the Atlanta metro area. Mr. Lackey, in this particular case, not only breached the contract with Mr. Lattimore, but he has committed fraud by taking the money from Mr. Lattimore and just disappearing and not investing it in these underserved neighborhoods as he had promised. It is these type of actions, Your Honor, which is going to actually deter future investors from developing these underserved neighborhoods in Atlanta and dealing with the public problem of blighted housing in the Atlanta metro area. And we asked the court to award punitive damages against Mr. Lackey in addition to compensatory damages to deter this type of behavior as a matter of public policy.
Mr. Jang, tell me if you can, what evidence is there of any attempt to contact Mr. Lackey and whether he ever responded once the money was paid?
Yes, Your Honor. I did send one demand letter over to Mr. Lackey. However, Mr. Lackey has not responded to my attempts to reach him. And I guess, Your Honor, I can also put Mr. Lattimore back on the stand again. I will represent to you, Mr. Lattimore has made verbal attempts to resolve this issue with Mr. Lackey without success.
Let's talk about that, Mr. Lattimore. Tell me what contact event Mr. Lackey and what the response or lack of response was.
So I've reached out to him via phone calls and text messages to see if he could actually begin to make payments to pay me back or pay the whole sum. Strangely enough, sometimes he would actually respond and say, hey, it's on the way. I'm dealing with a lot, but it's coming. He went as far to send like snapshots of wiring money that never really existed. So he would send like, I wired this amount, but the money never came through. And then he would give a different excuse as to why it wouldn't come through. And so we went on with that for probably maybe over 8 months, a year past the contract, and to the point when I retained Mr. Chang.
All right.
And Your Honor, in this particular case, I would refer back to the complaint. The total amount of damages that we're asking for in this particular case is $35,000. If you would subtract the amount of $12,500 of compensatory damages that we're asking for, if I'm doing my math correct here, I believe we're asking for $22,500 in punitive damages to deter this type of behavior in the future from Mr. Lackey and other individuals like him.
All right. And is that all you have, Mr. Chang?
That's all I got, Mr. That's all I got, Judge.
All right. I think by Mr. Lackey's default, he is admitted to essential allegations in the complaint. Based on Mr. Lattimore's testimony, I think there was an intent to defraud and string him along. Sounds like multiple failed promises and false statement to induce him and kept him strung along. I think it's sufficient conduct to impose punitive damages. I'm not going to go quite as high as what's requested. I think he's entitled to $12,500 compensatory. I'm going to award an additional $12,500 in punitive damages for a total award of $25,000 plus costs.
Thank you, Your Honor.
If you would, Mr. Chang, if you would send a revised judgment. I think you sent a proposed order, but that just dealt with the liability part of it. So
Yes, Your Honor.
Mr. Townsend, the proposed order will get it entered.
I will revise the order based upon the statements of the court here today. And this is my only case before the court. May I be excused?
You may be excused.
Thank you, Your Honor.
Thank you, Your Honor.
Sure. I am going out of order, but I did want to hear from folks on position 13, Rebecca Clark versus EAN Holdings.
Yes, Your Honor. I'm Attorney Bando for the plaintiff.
So I had a motion for default judgment and we got a late message from EAN Holdings new attorneys.
Yes, Your Honor, that's correct. Myself and also Susan Levy filed a notice of appearance late yesterday after receiving notice of the hearing. And we also filed a notice of placing damages in issue and a jury trial demand. Also let the court know that we do intend to file a motion to open the default due to proper case and still investigating the facts, but excusable neglect.
All right. Well, I'm in an opportunity to move, at least move to open default, and for Attorney Bando to have an opportunity to respond to that. Ms. Bando, you have any objection to me continuing this to allow them to file a motion?
Yes, Your Honor. They've had this, they were served by their corporate agent in September 22nd, 2020. Like, had this been just like, 30 days or 60 days or something reasonable, then yes, of course. I've been speaking to their adjusters after this lawsuit was filed. So everybody's been on notice about this lawsuit for almost a year. So I'm adamantly objecting to considering a motion for opening default.
Well, there may be a proper case. I'm always, I always lean towards trying to resolve disputes on the merits if I can, if there is a legal showing. I'm not sure that they can make that showing given some of the things that you've represented here, Ms. Bando, and how it looks in the record. But I think I need to, in all fairness to the defendant, I need to give them a shot to make their case for why this should proceed on the merits and default should be lifted. So, Mr. Christie, you got 30 days to get your motion to open default in. Ms. Bando, you'll have the requisite time to respond to that, and then we'll put it back on the calendar for hearing.
All right. Thank you, Judge.
Thank you, Judge. Sorry I lost you, but I'm back on and ready to go.
Thank you, Judge. May we be excused?
May be excused.
Thank you,
Thank
Judge.
you, Your Honor.
All right, let's go to position 4, Your Georgia Home Care versus a Superior Choice Medical Staffing.
Good morning, Your Honor.
Morning.
Andalakis for the plaintiff. Your Honor, I have an announcement, and I think it might be best to put myself and I see Mr. Lacey, the defendant, is on in a separate room along with Mr. Ducey, who is the owner of Your Georgia Home Care. They had a previous conversation this morning and agreed to pay the outstanding balance, and I believe our attorney's fees. I did not participate in that conversation. So if we could be put in a separate room, we may have an announcement for the court to, resolve this case.
All right, so Mr. Scandalakis and who else needs to go in that room?
Mr. Brian Lacey and then Brian Ducey.
Right. All right, I think I did that wrong. Let me close all rooms and try it again. There we go. I think I've assigned you to a room. Are you in there?
I was in there and then it bumped me back to you, Your Honor. And Mr. Lacy is on with us here.
Right, I was trying to get into the room as well, and it bounced me back just as Representative Skandalakis said.
Find it again. Okay.
Your Honor, this is Spencer Farmery on behalf of Milestone. I'm not sure if the court would be open to allowing us to go into a breakout room as well to discuss a possible settlement here. I've been trying to find a good time to jump in. This seems like a
All right. Mr. Farmer, which case is that?
Milestone versus Johnson, position number 7.
All right, and I see Mr. Johnson there. All right, so let's see if we can get you in.
Judge, I'm present, thanks.
Me, Mr. Johnson, and then Miss Oliver as well, Your Honor.
All right, why don't y'all go into breakout room number 2. Who else needed to go in that room? That was the
Johnson.
Johnson. All right. And Ms. Oliver? All right.
Your Honor, since you're putting people in breakout rooms, Sharice Taddy on National Collegiate Student Loan for Danielle and Sharon Freeman. If we could get a breakout room as well.
And this today, who's going with you?
Danielle Freeman and Sharon Freeman. Are you, I don't know if they're on Zoom or on phone. I know you have a couple on each.
We're on phone. We're having a hard time joining through video.
So Your Honor, in contrast to that, you could also let me get their phone numbers and I could call them.
All right, I think I can get them. I think I can get one of them in there. Let's see. This today. All right.
I can't hear anybody. Can you hear me?
Who's speaking?
And Your Honor, I just wanted to note, I can't, on position 5, I cannot talk to Mr. Vasquez because he's not represented by an attorney.
Correct me if I'm wrong. And they would be willing to consider, you know, a duration that we'd ask you to propose. I can give you a final.
The total amount, Spencer, it was $4,285.93. For trial. Okay.
If we subtract off
Mr. Vasquez?
Kevin, were you
Yeah.
gonna say?
Mr. Vasquez, so this.
Can you hear me?
Yes.
Oh, good. Okay.
Mr. Vasquez, you know, this case is on calendar.
Kevin, did you hear that or that I read out? That includes waiver of late fee.
Do you have an attorney?
I do not have an attorney.
And I believe there is a. There's a motion. Yes.
I get a hard time to hear you. You know, I can barely hear you. Say that again, I'm sorry.
Mr. Vasquez, we've been down this road before, and I believe You were advised that you needed to get an attorney.
Well, not really, not really. I submit a letter on, I think it was on June 2020. 24, I'm sorry, on 20. And I've been waiting for them to send me any, so they can answer it back, but they never sent anything back. So until, I think it was like, like a month ago or something like that, when I received this letter.
All right, there's been plenty of time for you to retain an attorney to represent the company. And so I am granting the motion to strike the answer. So we're going to reset this for hearing on damages.
Thank you, Judge. May I be excused?
Yeah, and Mr. Vasquez, you may be excused.
And Your Honor, we have an announcement.
Hold on one second. This is your Georgia Home Care?
Yes, sir, Your Honor.
Yes.
The parties have agreed to resolve the matter by the payment of $17,516, which includes the principal plus attorney's fees. Mr. Ducey, on behalf of his company, the plaintiff, is waiving the interest. Mr. Lacy has already paid through a wire transfer $10,000 and will pay another $5,000 today, but he requires 30 days to provide the balance. So what I'm asking the court to do is to basically hold this case for announcement for another 30 to 60 days or 30 days, whatever the court wants. And when the money comes in for the balance, that we will just enter a dismissal with prejudice.
We'll look for your dismissal within 30 days. Otherwise, we're going to trial.
Thank you, Your Honor. May I be excused?
Yes, you may be excused.
Thank you,
Thank
sir.
you.
All right, let's go to position 7, Milestone Community Association versus Johnson. I think they're in a breakout room. And I think position 8 is in a breakout room. All right, let's talk Riverwalk Homeowners Association versus Miller.
Good morning, Judge. Beth
Patient.
Plaintiff. We are in a default situation. We have filed a motion for default. I have a witness present, Miss Christy Barber, who is here to testify and prove up damages. And I do believe Mr. Miller had announced his presence as well.
Yes, I'm here.
All right, Mr. Miller, you understand the posture that the case is in? You understand a lawsuit was filed against you and you failed to answer the time to respond. And so now in default, and all of their allegations of non-payment are deemed admitted. So,
I understand that, but I've had an ordeal for the past, since 2016, when some Forsyth cops attacked my son, been attempted murder. They got me fired from a contract in Maryland. I was about to lose my house, but by the grace of God, I got a job working at a company called McDonald's, and I'm powering back financially. I owed about $30,000 on my house because I was about to lose it. It's paid up. I paid up my homeowners association for this year, and I'm coming back, and I admit I owe them $2,000 some dollars, and I will pay them. But it's just I needed time to come back, and I'm associated with a very fine company, McDonald's, and I'm above ground. They tried to kill me, and I'm living in Dallas. They've sent marshals to my house that I understand trying to serve things, and I didn't get any communication because I had to flee my home. Right now I'm engaged in federal court to extract, but basically I would like Johns Creek Police Department to eliminate it because they're a corrupt police department and they provide absolutely no service. So I really have nothing to say except I will pay, and I'm going to come home at some point, hopefully in safety, and live like an American citizen.
All right, so you acknowledge that based on, you had some life or death circumstances.
Yes, exactly. I have no problem, Ben. That's not germane to this court hearing. I am taking care of that, but I am just saying I commit to paying my bills, just as my daddy did. I will pay them.
All right, is there, you acknowledge that there's still some back due amount that has not been paid?
I did not have the money. They made me lose contracts and made me flee my home. I was on the point of losing everything. My family would not have home. I, again, they have hooked up with a very powerful corporation. They're paying me well, and I'm coming back, and I'm coming back home.
Let me ask you this, Ms. Taylor. Mr. Miller is here. He seems like he's committed to getting on track with the payments. Is there any room for negotiation here?
I'm always willing to talk. I will say this, Your Honor, back in August of 2019, and I know the world was very different then, but back in August of 2019, we had reached a payment agreement with Mr. Miller to pay $300 a month, and he didn't keep his end up of that bargain. And again, I'm no judgments. I understand that he has a lot going on. From the association's perspective, the reason we're continuing to pursue this suit is the amounts due date back, the delinquency dates back to January 2017. And as Your Honor knows, the association has a 4-year statute of limitations. So if it behooves the court, I think we can move forward with the judgment and then maybe possibly have additional conversations with Mr. Miller to get him on a post-judgment payment plan. But we're kind of up against that statute of limitations situation.
Regardless of statute of limitations, I will pay. That's just the way my family is.
Right. And Mr. Miller, I'm sorry you're dealing with these circumstances, and the association certainly wants to continue the conversation with you to try to work something out. I'm
paying between $2,000 to $4,000 a month to live away from home. And I've been doing this since 2017.
All right.
And now I'm in a point where I can actually fight back and get my bills and still maintain safety away from my home and those dangerous domestic terrorist cops called Forsyth County Police Department.
I gotta get you back on track.
Okay.
The issue is that we're dealing with today, and that's unpaid assessments and what the association is entitled to based on that under the law. So I'm going to have to award them a judgment, grant them a judgment today. We're going to hear proof as to the amount. If you're free to have a conversation with them about resolving it, and if you're able to reach a payment agreement with them, then they won't execute on the judgment. They won't, there are things they can do.
I can guarantee I can execute on it now because again, I'm working for a pretty big company named McDonald's, which is worldwide, so I can get it done.
Right.
Just God bless me, and I'm coming back.
All right, so let's hear from Ms. Taylor on damages.
Thank you, Judge. Ms. Barber, will you raise your right hand? Do you swear and solemnly affirm the testimony you give the court today is the truth, the whole truth, and nothing but the truth?
Yes, I do.
And can you please state your name for the benefit of the court and Mr. Miller?
My legal name is Christine Barber.
And Ms. Barber, are you the property manager for Riverwalk Homeowners Association?
Yes, I am.
Okay. And as the property manager, are you familiar with the books and records of the association?
Yes, I am.
And did that include the duly recorded declaration of protective covenants for Riverwalk?
Yes, that's correct.
Okay, and pursuant to the governing documents, particularly the declaration, is every owner of property required to pay annual assessments to the association?
Yes.
And pursuant to the declaration, if a homeowner fails to pay the annual assessments, is the association entitled to recoup late fees, any interest accruing on any unpaid assessments, plus its costs of collection, including reasonable attorney's fees actually incurred?
Yes,
Okay. And as the property manager for the association, are you charged with managing and maintaining the account ledgers and histories for homeowners? Here come the court. The account ledgers and
Yes.
history, sorry guys, account ledgers and histories for homeowners. And are you familiar with the account ledger and history for the defendant in this matter, Mr. John Miller?
yes,
And has he been delinquent with the association since January 1, 2017?
yes, that's correct.
Okay, and so, and again, we've heard the hardships he's faced, but basically he's had a balance with the association for about 5 years now, correct?
Correct, yes.
Okay. Can you share with the court to date from January 1, 2017, how much to today's hearing, how much in principal does Mr. Miller owe to the association?
His principal is $2,617.50.
Okay, and has interest accrued on that principal at the rate of 18% per annum pursuant to the declaration?
That is correct.
Okay, and how much
the
in
amount
interest?
is, sorry, the amount is $963.94.
Okay, and in addition, has the association incurred its cost of collection and attorney's fees in connection with pursuing this matter against Mr. Miller?
Yes,
Okay, and is the association entitled to recoup those attorney's fees pursuant to the declaration?
yes,
Your Honor, we did submit an affidavit in support of our motion for default judgment, but I also state in my place as to the attorney's fees and expenses and court costs sought by the association. I can state in my place that I'm an attorney duly licensed to practice law in the state of Georgia. I'm a partner with the law firm of Winter Capriola Zenner LLC, and have been practicing condominium and community association law for over 17 years now. This matter was referred over to my firm by the association after the defendant was 2 years delinquent. So we started collection procedures in April of 2019. In 2019, we sent 3 demand letters to defendant. We were able to reach a payment plan with him, prepared a payment plan agreement letter. Unfortunately, he defaulted for, again, no judgment. So then the association asked us to continue collection efforts. So we sent additional demand letters as required by the declaration in 2020. We filed the instant action. We tried to personally serve defendant. We used the services of a private processor server to do so, both at the property address and his address in Texas. As he stated, he was not opening the door. So we did a motion for service by publication. Your Honor entered an order for publication, conferring personal jurisdiction over the defendant in this case. We filed the motion for default. We ensured publication occurred. We filed the motion for default judgment and prepared for today's hearing. And I did send a defendant pursuant to the court's hearing notice, a copy of the notice of the hearing, as well as a Zoom information for same. In total, my firm spent 16 hours of time from April 2019 through today, so for about 2 years in connection with this matter. And the association has incurred $4,087 in legal fees, and then $1,011 in litigation expenses, and $49.55 in court costs. The litigation expenses, most of which involve the services of private process servers in an effort to perfect personal service before we had to go the publication route. So the association is seeking these legal fees, expenses, and court costs pursuant to the declaration, as well as pursuant to OCGA 44560E, which mandates, to the extent provided in the covenants, the obligation for the payment of assessments and fees arising from covenants shall include the cost of collection, including reasonable attorney's fees actually incurred. That is our case. And if Your Honor wants me to go over the numbers again, I'm happy to do so.
If you would go through the numbers.
Yes, sir. So the association is seeking principal in the amount of $2,617.50, interest in the amount of $963.94, attorney's fees in the amount of $4,087, and then court costs and expenses in the amount of $1,061.21 for a total judgment of $8,617.50. $729.65. And I did email to Mr. Townsend a proposed order for the court's consideration at the right time.
All right. You are entitled to judgment in the amount requested. We will enter. You said that you sent the proposed order.
Yesterday to Mr. Townsend.
We will enter the proposed. We will enter the proposed judgment. That will probably be entered today, so it behooves you, Mr. Miller, to have some conversation with Ms. Taylor within the next 30 days or so, and see if you can reach some kind of conversation. Otherwise, they can.
Yeah, I would like to do that today. Again, like I said, I was about to lose my house. My house is secured, and I would like to, and I paid the homeowner, they're no longer the homeowners association company, and I paid the up with the existing homeowners association. And the only thing I would like to do is just, this was the events that happened to me and my family was just kind of unusual. And fortunately, I'm above ground, unlike a number of other people, Ahmaud Arbery and others.
All right.
So I'm happy. So I don't think I want to do is just work out and just pay it off, pay it up, and then I want to be able to move on my life and hopefully be able to return home to Georgia in safety.
All right. Thank you, Miller.
I was just going to say, I'm sorry to interrupt you, Judge. Mr. Miller, I believe you should have gotten a couple of my letters, probably the letter with respect to notifying you of this hearing. It has my phone number and my email address on it, so you're just welcome to contact me.
When I have called that number, it doesn't ring.
Yeah.
The voicemail is full. So I would want to talk to you today, and hopefully their phone rings. And
why don't you give me your phone number right now, and I'll call you so we can get off the court's time.
Yeah, call me at 510-710-5239.
I'll call you in a few, 5239. I'll call you in a few minutes, Mr. Miller. Thank you, Judge. We won't take up the court's time. Thank you.
Appreciate it.
Thank you, Mr. Miller.
Thank you very much.
Thank you, Christy.
Thanks.
So let's hear on Milestone Community Association versus Johnson.
Hey, Your Honor, we were unable to come to a settlement agreement, so we're ready to proceed with trial when you'll have us.
All right, and we'll hold on.
Your Honor, I have a quick announcement on a National Collegiate Student Loan versus Danielle and Sharon Freeman.
Go ahead.
We'd like to ask for a continuance. I know they were having some issues because they were on the telephone on whether they were going to make it back into the courtroom or not. But all the parties have agreed that we'd like to request continuance. We're very close to settling. I'd like to have 30 days, if 60, if you'll give it, but I'll take 30.
We're present as well, Sharon and Danielle.
All right, we'll give you 30 days.
Thank you, Your Honor. And that's my only matter, if I may be excused.
You may be excused.
Thank you.
Thank you.
We'll be in touch.
All righty, thank you.
All right, so let's go forward with Milestone versus
Johnson, Brandon Johnson. I'm present, Judge.
All right, so we have a complaint and we have an answer denying liability. So Mr. Farmer, we can go ahead and prove the case.
Okay, Your Honor, this is a case for a collection of delinquent homeowners assessments. Defendant's answer, he admits that he hadn't paid the 2019 and 2020 assessments at that time. At this time, he also hasn't paid the 2021 assessment. Ms. Oliver is here. She will testify to the assessments, late fees, interests, and that the association has also incurred attorney's fees and court costs. I have a statement prepared as to the attorney's fees and court costs. These amounts accrued pursuant to the declaration of covenants for Milestone. And with that, I'll call Miss Oliver to the stand. Miss Oliver, will you raise your right hand? You're also muted. Can you unmute yourself, please?
Okay,
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I will.
Please state your name, employer, and job title for the court.
Kevin Oliver. I'm employed by Fieldstone Association Management, and I am a portfolio manager, and I manage about 24 HOA communities.
That includes Milestone.
Yes, it does.
Are you responsible for overseeing the accounting and collection of assessments for the Milestone community?
Yes.
Are you familiar with the accounts for Milestone?
Yes.
Do you keep any sort of accounting documentation in your responsibilities as a manager?
Yes, the account ledgers.
Specifically the account for Mr. Johnson?
Yes.
Does the defendant have an outstanding balance?
Yes.
What documents, or does Mr. Johnson own the property in the community related to this case?
The limited warranty deed.
That document supports his ownership?
Yes.
Your Honor, if I may share my screen. Your Honor, I'd like to present a copy of the limited warranty deed as Exhibit A. We filed a stipulation of evidence to the record yesterday with the court. This is that limited warranty deed. Then scroll down. Ms. Oliver, do you recognize this document?
Yes.
Here, I'm gonna scroll through it real quick. It's pretty long. But do you recognize this document, and can you identify what it is?
Yes, it's the declaration of covenants for Milestone.
Do you normally keep a copy of the recorded declaration in your course of business as the account manager?
Yes.
Your Honor, I'd like to present a copy of the declaration as Exhibit B.
All right, Mr. Johnson, you have any objection to the warranty deed or the declaration covenant?
Your Honor, no, I am the owner of the said property.
All right, and you're aware of the covenants and that covenants apply?
I've read every single page.
All right, thank you, sir. So those are admitted.
Your Honor, when I'm questioning the witness, do you want me to stop sharing my screen, or is it fine if I keep it up?
Keep it up if you're going to do it.
Ms. Oliver, which article of the declaration automatically makes the defendant a member of the association?
Article 3, Section 3.1.
Your Honor, that section is up on the screen currently.
Mr. Johnson, you don't dispute that you're a member of the, that you're a member, is that right?
I do not dispute that I am a member, Judge, but am I allowed to add some context to this document, or do I need to wait my turn?
You should wait your turn. I'm just trying to figure out what exactly is in dispute and what's not in dispute, so that we can move forward a little bit faster.
Oh, sorry, Your Honor. So, Ms. Oliver, does the association have the ability to impose assessments on owners of lots?
Yes.
Let's see, I'm trying to speed it up. The defendant has not paid his assessments, correct?
Correct.
Do you recognize this document?
Yes, I do.
What is it?
It's his payment history, his ledger.
And Your Honor, I'd like to present a copy of this ledger as Exhibit D. Exhibit C, I don't think we need today. This is Exhibit D that I'd like to submit to the court for record.
Mr. Johnson, you have any objections to that? That's what they say they think you owe.
I do have objections, right? I have objections to the additional attorney fees and late fees that are here. I am.
You don't have any complaint that that's somehow an inauthentic document or that it's not their business record?
No, but I do have suspicions that there was an inauthentic document that was presented to me in the breakout room.
All right, we'll come back to that.
According to the association's records, how much does the defendant owe the association for non-payment of assessments through May of 2021, Ms. Oliver?
$2,974.
Just for principal, is that amount $1,800?
Yes.
Is the association authorized to impose late charges on assessments not paid when due?
Yes.
Is that amount $60?
Yes, it's 10%
Is the
of
association,
the principal amount, which is $60.
is the association authorized to collect interest on each assessment that's not paid when due?
Yes,
And what amount is the interest to date?
10%.
Has the association incurred any additional fees in its effort to collect assessments?
Attorney's fees, yes, attorney's fees and court costs.
Your Honor, I have a statement as to attorney's fees. My name is Spencer Farmery. I'm an attorney duly authorized to practice law in the state of Georgia and associated with the law firm Duro and Duro. Duro has performed legal services on behalf of Milestone since 2018 at an attorney rate between $225 and $250 per hour and a paralegal rate of $95 per hour. These rates are reasonable and customary in the Atlanta area. Legal services in this case have resulted in expenses in the amount of $1,898.82 attorney fees and $283 in court costs. It's the regular practice of my firm to bill time for the legal services we perform and such time and a description of the legal services entered at or near the time the association incurs the charge. Billing statements generated by the entry of such billable time are kept in the ordinary course of business. Up on my screen right now is a copy of our bills. I'd like to tender a copy of those bills as Exhibit E. I can scroll through for Mr. Johnson's review.
Yeah, and Judge, I would like to note, if we go back up to that first page, note the date of 4/19/2019 so that we can address that coming back. This is the first time that I was contacted by the association through the lawyers in reference to balance owed. So I would like to refer back to that when I get my turn.
All of the attorney's fees have actually been incurred and billed to my client with the exception of 2.5 hours to prepare for and attend today's hearing. That totals $562.50, and that amount is included in the request for $1,892.82. Article 4, Section 4.2 of the Declaration in Georgia law at OCGA 44560E support the recovery of reasonable attorney's fees and actually incurred, and the association would request that the court enter judgment, including those fees.
All right, Mr. Farmer. So I'm looking at the bills here, which, including today's time, would be several $100s. Where do we get to the rest of it that makes up 1,800 plus?
So I can scroll through. This is a notice of lien and suspension of rights letter and filing of the lien. If you want me to slow down at any time, please let me know. This is a subsequent, or this is a warning of suit letter that was sent to Mr. Johnson This is a second warning of suit letter that was sent to Mr. Johnson in 2020 after that assessment wasn't paid. Here is filing the complaint, preparing the complaint, entry of service, reviewing answer. We sent a failure to pay letter to Mr. Johnson. And then we had some communications with Mr. Johnson. I prepared this amended complaint previously. We filed it yesterday just so the court had it on notice. And then here is, once we received the court's notice, notifying the trial and discussing with Miss Oliver that.
All right. All right. Anything else you have for me, Mr. Farmer?
No, Your Honor.
All right. Well, Mr. Johnson, what do you want me to know about this?
Yeah, absolutely, Judge. Maybe I'll just give a quick introduction to myself as Kevin and team were allowed to do so. I have a background in commercial real estate portfolio management for the past 5 years, and currently I'm a technology leader with T-Mobile, leading a global team of product and technology, very, very large team. I want to give some context to this, Judge. December 7, 2018, I closed on my property in the Milestone community at 3694 Bradford Way, Atlanta, Georgia, 30331 as the first member of the community. So I was the first person that started out the community and purchased this property. At the closing table, I did make a capital assessment to join the community association. And then I paid, and that was $500. And then I paid a $50 proration for the time left from December to January of 2018. As we rolled into the year of 2019, which the plaintiff says that HOA fees were due, there was a little bit of confusion about what happened at the closing table. There was an assumption that I paid the HOA fees for the upcoming 2019 year, but that was actually the capital assessment. And that's for me reviewing the documents. The first time that I was ever communicated by the association that I was liable for the HOA fees for 2019 was somewhere around the first quarter, which is that data for 2019. So I never was welcomed to the community by Kevin or the team, or there was never a cadence that was set up with us as to when association fees were due. I'm sure if Spencer pulls back up that document, you will see that there is no date that was set for the community. So number one, I'm not making my case that I do not owe the HOA fees due, because Judge, as I can share, if I could share my screen, I'll kind of talk through my documents as well. Let's see, Chrome tab, application window. Let's see. And hopefully you can see my window. Can you see my window, Judge?
I cannot see it.
Okay, open system preferences, and then I need to allow, but I'll talk through it, Judge, and then let's see. Okay, Cisco web meetings I need to allow. But Judge, at that time I paid, when I closed on the house, Judge, I paid probably close to $9,000 in closing costs plus $2,000 in a down payment to hold the property while we went through the proceedings. My issue here is that I was never in good faith communicated to by the association of the dates that the HOA fees were due. The first time that I was communicated was through a lawyer, which was unnecessary given that I paid $12,000 to purchase the home. $600 is not far off. So had I been communicated with, Judge, in good faith, I would have paid those HOA fees that were due in, let's say, January. The problem that I have too, Judge, is that in the breakout room, I closed on December 7, 2018. Spencer showed me a document saying that I was reached out to with the budget and the schedule of fees and the due dates for HOA fees, December 1st, 2018. That was a week prior to me closing. Very presumptuous that the deal would go through. And I'm not sure that that's an actual document because that was never received by me in my mailbox. And then on top of that, Judge, I would like to make the case that Kevin and the Fieldstone community are taking advantage of the community by not making proper communications. I have several documents from, and I wish that I could share, but some reason it's not letting me share. I'll try another screen. I don't know if you can see anything at this point.
Can't see anything.
But, okay, I'll still continue to work through it, but Judge, to build the case on them continuing to be negligent. February 2nd of this year, Judge, the lights in our community, the street lights were actually going out. The community and us tried to resolve, and I have text messages, Judge, and I can follow up as well.
I'm sorry, I don't want to get into the issue of what they weren't doing with regard to services that they're supposed to provide. That's a separate issue from the liability and responsibility for assessment.
Judge, I agree, but it's not to make the case about what they weren't doing. It's to make the case that they were negligent in the communication in the business with the community. And so I
focus on what communications they were or were not making regarding the assessments. Were you ever billed for assessments?
Absolutely, Judge. I'll go back and stay on track to that. I was never billed for the assessments. I tried to every time I was contacted by the lawyer, I picked up the phone. I tried to resolve it. I've even called Kevin and her assistant, and nobody wanted to speak to me because we were going back and forth about payments that were owed. There was never a bill that was generated to me. The first bill that I ever got from the association was first quarter, second quarter of 2019. Once others started to buy into the community, now there became this formal document. From December on, when I purchased this property, I had no communication with the association. They never ever reached out to me at all or billed me or told me when association fees were due. And it's not in the document.
All right, so, but you did start getting bills after April of 2019.
That's correct. So let's talk about the bill that I received. The bill, I was contacted by a lawyer, Judge. Okay, so within the, not only was assessment fees being asked for, I was then being asked for us to pay lawyer fees or processing documents. So as we began those conversations, I said, hey, I was never ever notified of the specific cadence of when HOA fees were due. And now you expect me to pay lawyer fees when in good faith, if you sent me a letter or you could not get me, you could have picked up the phone. Judge, I never ever received a bill. So I was trying to mitigate that with the lawyers to say, hey, how am I responsible for this? I was never billed. I never ever received a bill from the team. You know, I'm ready to pay today. I was ready to pay then when I was on the phone. I can write a check for the $1,800, but I did not apply the payment because, Judge, I didn't know if it was, number one, going to be accepted. And then there was additional fees, and we have already started to have litigation back and forth between me and the lawyers. I've never spoken to the association. Kevin has never contacted me.
All right, so how much do you contend you would owe just for assessment?
The principal amount would be $1,800. In good faith, Judge, I agreed with Spencer and the rest of the team and tried to settle and say, hey, I can pay the late fees only because maybe there was miscommunication. So I tried to be the bigger person, but I was not, which is $60 times 180. But the fact that Kevin and team went to a lawyer instead of contacting me, the first person in the community, to say, hey, hey, Mr. Johnson, here's when the fees are due. You know, I did not pay. And so, you know, I'm not disputing that I owe the HOA fees, but I'm disputing that there was unnecessary involvement with the lawyers, which incurred additional fees that did not have to be incurred had there been proper communication from the association directly to me on when the cadence was. This is a brand new community. I was the first person in the community, and that's why I agreed to pay any specific late fees as a sign of good gesture to get this taken care of.
Judge, may I say something?
Hold on a second.
Okay.
Mr. Johnson, is that all that you want me to know? I want to give you a chance to tell me anything that you want to tell me that this issue.
I mean, the other things that I would like to say is throughout my several attempts to contact the association, I was never contacted. I have documents signed from my community as well, others saying the same thing about communication with the community as well. I never, just to be honest, I never received a bill. The first communication was 5 months after I signed my documents to purchase a home. I was communicated by a lawyer and then subsequently received that ledger that and access to the Fieldstone accounting that Spencer and Kevin just mentioned. So I never even had understood forms of payment or anything like that for the HOA fees. So I'll stop there, Judge.
All right. Ms. Farmer, you want to respond, or Ms. Oliver?
Your Honor, so there's a lot to unpack there, but I'll start off by saying from a legal matter, the declaration does not require that a formal bill be sent to an owner. It simply requires that a budget be provided. That budget is required to be sent out at a certain time frame regarding the 2019 assessment. It was sent, and as Mr. Johnson stated, he purchased his property after that date.
Judge, I would have asked that they would show you the letter.
Yeah, I can show the letter, but I'll put Miss Oliver back on the stand, Your Honor. If Miss Oliver, remember you're under oath. Do you swear to tell the truth?
Yes, I do.
I'm gonna share my screen again. So this is a letter that Miss Oliver, was this letter mailed out December 1st, 2018?
Yes, and it's dated December 1st, but it probably was not actually mailed out. We use a third-party vendor for our mailings, and all of our coupon letters and budget letters are all dated December 1st, but that may not have actually gone into the mail until, December 10th, December 15th, but we would not have generated that letter if you had not been living there, because there wouldn't have been a reason to generate it. So it was generated specifically for you.
And Miss Oliver is, were similar letters sent out in 2019 for the 2020 assessment and in 2020 for the 2021 assessment.
Can you show those?
Can you grab this document? Was this letter sent out December 1st, 2019, noticing the 2020 annual assessment?
Yes.
Was this letter sent out December 1st, 2020, noticing the 2021 annual assessment?
Yes.
In your experience as a property manager, can you walk through the process that the association follows to notice owners of assessment? Do you do anything in addition to sending these letters?
Yes, what goes with that as a second page, if it's an annual assessment only paid once a year, there's a one-page statement that goes with this letter that the homeowner can use to pay their HOA assessment with. If it's a quarterly payment paid 4 times a year, they get a small coupon booklet. If it's a monthly payment, they get a coupon booklet with 12 coupons to pull out that they can pay with. Most people now use bill pay or our online payment service, but we still have to send out the coupon booklets. But this would have only had one other page with it. And I remember that he said he did receive the one for 2020 and 2021, but that he wasn't going to pay those because the 2019 one was still not settled. So he did not pay 2020 and he's not paying 2021.
And then as a final question, are you aware of anything in the declaration for Milestone that requires that this courtesy letter be mailed out?
No. We have to send that budget.
Yeah.
Which is sent.
Judge, I would like to respond to the documents that were presented, if you would allow.
Yes, sir.
If you notice, that first letter was sent December 1st, 2018. I didn't close on the property until December 2020.
I said it was dated.
Oliver, let him talk.
Yeah, we interrupt each other.
I have some concerns there, Your Honor. I mean, it's pretty presumptuous to send out a letter December 1st, 2018 to someone who was not a resident of the property. I didn't sign and close documents until December 7th, 2018. I never received that document. That was the first time that I've ever seen it today. Judge, I never received a budget. If you go to if you look at the 2019 budget, which was the second screen that they showed, Judge, that was the first time that I gave a budget. Just like I explained, I received a budget just like I explained. That was given first quarter of 2019. Okay, so we were well within 2019 before I was even assigned what the HOA fees or the budget. So if, according to Kevin Oliver's own words, we have to provide the budget was not provided to me. And there's no way that you could have sent a document to me December 1st and I didn't close until December 7th.
I have a question for Ms. Oliver.
Yes.
So we have the budget is presented and there's no dues are paid. So
I can't hear you.
The budget is presented and the notice that the annual assessment is due. So when homeowners, what is the standard operating procedure for the association if somebody is late on a payment? If so, it's due on such and such date and it doesn't get there in 30 days have passed. What's the standard procedure?
For an annual payment like this one, it's due on January 1st. It's late on January 10th. Towards the end of January, we send out a late notice saying that they're late. Then we send out a final notice saying that this is their final notice. And usually in January, we will give people the benefit of the doubt for about another month. And then we turn them over to Spencer's firm for collections.
All right. Do you have the notice that was the reminder notice that was sent to Mr. Johnson and sort of the last chance notice that was sent to him before it was sent to the attorneys?
I don't have that right now. I can probably produce it, but that was the other thing I was going to say. We do not send anybody to legal until we've sent a first notice and a second notice. So he would have had to have gotten those before he was turned over to legal. That's pretty much, we have to do that.
Mr. Johnson saying here today that the first notice he ever got that it was late was when he got it from the attorney. So you dispute that?
Yes.
And Judge, can I respond as well? I would like to know what good faith efforts did Kevin and her team do to contact me outside of a letter, right? Knowing the risk that this is a new community, and with the United States Postal Service, it may not even be in the system. So what was, from a good faith standpoint, that they tried to contact me outside of a lawyer or outside of a document?
I'm not going to require them to answer that question, but I think that is a good question.
Your Honor, I have two interjections. First, Mr. Johnson stated he received the budget in the first quarter of 2019. Payment was not made.
Second quarter. Let's be clear, Spencer. I never said a specific date. Whenever that first budget was sent out to the broader community, once others started to come on and buy in the community, that's when I received it, which was then when I felt that the team wanted to then communicate. Okay, so I believe I received the budget that was for upcoming 2020.
Second,
I didn't do a budget.
Second, the budget is provided prior to the assessment becoming due. So if you follow Mr. Johnson's timeline of this notice being sent out, Mr. Johnson closing on the house on December 7th, 2018, the assessment was already noticed at that time as due January 1st of 2019. At that point, it becomes Mr. Johnson's obligation under the declaration to pay that assessment and to contact the association regarding what assessment is due. The association doesn't have an obligation to renotice assessment due dates.
Mr. Spencer, and to that point, you sent the letter December 1st, 2018. I'm sorry, Judge, I can't hear you.
I'm going to stop you. I think I've heard everything that I need to hear from the testimony to make a ruling here. Mr. Farmer, break down the amounts that you're seeking. How much in unpaid assessments? Is it $1,800?
Correct, Your Honor.
All right, and how much in interest and late fees?
Combined, $304.11. Separated, the late fees are $60 and the interest is $244.11.
All right, and how much in attorney's fees?
$1,898.82.
All right, here's my judgment on this.
Your Honor, just the court costs would be $283.
$280. All right. Clearly, there's no dispute that Mr. Johnson owes the $1,800. He acknowledges it's owed. There's a time value of money. There's interest. There's late fees that everybody's aware of. So I am awarding the $1,800. I am awarding late charges and interest in the amount of $304.11. You know, I think there's fault here to go on both sides, frankly. I think, you know, this is a new association, and I am not convinced that all the requisite notices were sent timely to Mr. Johnson, which caused him to have some substantial uncertainty over what he legitimately owed and didn't owe. And I think at the very least, the involvement of the attorneys in this case, based on the evidence I have seen, is premature. I understand there may be evidence out there of some attempts to contact Mr. Johnson before an attorney was already engaged, but I have not seen it today, and today is the time to produce it. So not seeing any evidence of that, you know, my finding is that there wasn't some contact and an attempt to resolve it. That's the fault of the association, but there's also some fault.
May I say one thing?
No, ma'am, I'm issuing my rule.
Okay.
I also believe there's some fault in Mr. Johnson, because Mr. Johnson knows going forward that he's responsible for assessments, and he knows that they have to be paid. And ultimately, you know, once the attorney's involved, they're not going to get their money unless they proceed with the lawsuit. So there were ways in which, Mr. Johnson, you could have made a partial payment. You could have paid what you knew you owed, and I might have dismissed the claim for attorney's fees entirely, but you didn't do that. So I am going to award court costs for $280 in the amount of $283 and attorney's fees in the amount of $500. That's my judgment.
Thank you, Your Honor. Do you want me to prepare an order for the court and email to Mr. Townsend?
Yes, please. And please contact.
What's that total?
And Mr. Johnson, if you have any objection to it, you're free to register that objection, but absent any objection, I'm going to enter the order and the judgment.
I do have an objection to it, Your Honor. I do have an objection to it, Your Honor, because I was never contacted. I don't think they made the case to say that they contacted me. You saw that there was documents that predated me even closing on the property. So, I think, the late fees is fair, but they were prematurely engaged in their lawyers. So they should be responsible for their lack of communication.
Johnson, I've already ruled. So, neither side may be totally happy with my ruling. You have the opportunity to appeal. If you want to appeal, you have 30 days from the time the judgment is entered to appeal if you want to appeal. But that's my final judgment.
And what is the final judgment? Can you run down the numbers again, Judge?
It's assessments in the amount of $1,800, $304.11 in late fees and interest, $283 in court costs, $500 in attorney's fees. And like I told you, Mr. Johnson, if you paid the other, if you just paid the assessments that you knew was owed, they wouldn't be getting any attorney's fees and costs today.
Okay. Thank you, Judge.
All right.
Thank you, Your Honor. May we be excused?
Thank you, Your Honor.